His assessment of the State's anticipated testimony, hearsay, extracts from the case docket, a judgment, Police Standing Order 252, and a collection of photographs of Mr. Yutando Sione, the central figure of his plea in limine, which he articulated thus, and I quote, "I will request this Honourable Court to order a trial within a trial on the basis that the evidence obtained following the removal of State Witness Yutando Sione from Infinity Pub and Grub at approximately 20:15 on Monday 27 April 2015 is inadmissible. All the evidence following his removal and thereafter is tainted as the result of the police assaulting, intimidating and unlawfully pressurizing Ellis to implicate me. Therefore, the evidence obtained against me was unlawfully and unconstitutionally obtained by the State, with the result that my right to a fair trial has been violated." Close quotations. His plea on the merits was enumerated as follows: I deny the allegations that the State has made against me. I deny specifically ever approaching Ellis and requesting ordering asking him to find a hitman hitmen to have my wife, the deceased, Jade Panayiotou, killed. Jade and I had been married for just over 2 years at that point in time, and as far as I was concerned, we were happily married. I loved my wife Jade, and in February 2015, we made a decision to buy a house in Lovemore Park for approximately 2.2 million, in which we were going to move in together and hopefully spend the rest of our lives therein. By the time this incident occurred, the necessary bond fees and deposit has already been paid, and it was just a matter of the two of us moving in. Prologue. Jade and accused number 1 were married to each other and resided in a gated townhouse complex situated at 19 Stellan Glen, Deacon Road, Kabiga Park, Port Elizabeth. He was and is a businessman, and she, during her lifetime, a junior teacher at Revere College Girls High School in Uitenhage. Jade and her colleague, Ms. Cherise Taylor Swanepoel, Ms. Swanepoel, were accustomed to travel together by Uitenhage each day by car, alternating between the usage of their respective motor vehicles weekly. Ms. Swanepoel lived at 25 Ruth Street, Glenherd, and each would be collected from their respective homes by the other. To facilitate Jade's pickup, Ms. Swanepoel was accustomed to send her a text message when leaving her home and then collect her at the gate of the complex. This was the scheduled arrangement, except that on 21 April 2015, Ms. Swanepoel had texted Jade to inquire whether, by reason of the inclement weather, she should not drive into the complex and collect her from her home. The reply received was that she would walk to the gate. On Ms. Swanepoel's arrival at the entrance, however, there was no sign of Jade, and her text message to announce her arrival went unanswered. The uncontroverted evidence is that the message was sent at 06:33. Perplexed thereby, Ms. Swanepoel dialed Jade's landline, but it too went unanswered. Sensing that something was amiss, she telephoned accused number 1 on his cell phone, and when he answered, inquired about Jade's whereabouts. His riposte was that she had gone to work. The upshot of the conversation was that accused number 1 opened the automated gate to let Ms. Swanepoel in. It is furthermore common cause that accused number 1 and Ms. Swanepoel drove out of the complex and along its periphery to look for Jade, but to no avail. Fortuitously, they encountered a police vehicle along the way, and thus began the search for Jade. A number of people, including accused number 1, participated in the hunt for Jade in various locations within Port Elizabeth, Uitenhage and its environs that day. She, however, remained unaccounted for. Having widened the parameters of the search area the next day, a police tracking unit discovered her body later that morning on an open field close to a gravel road which dissects Wincanton Road on the outskirts of Uitenhage. The area was secured and a police forensic unit dispatched to the scene. The events which unfolded subsequent to Jade's discovery was narrated by a number of witnesses. What follows is a précis and, where necessary, an appraisal of their testimony. Dr. Kevin Fourie, the head of the clinical unit, Forensic Pathology Services, conducted a post-mortem examination on the cadaver on 23 April 2015 and concluded that the cause of death to be consistent with bullet wounds to the head and chest. His chief post-mortem findings were recorded on the medical post-mortem report, Exhibit L, as follows: perforating bullet wound to the skull and brain, perforating bullet wound of the chest involving the left lung, perforating bullet wound of the chest involving the spinal column, spinal cord and the right lung. This wound track can be aligned to a bullet track through the right upper limb, bilateral hemothorax. He recorded the external appearance of the body and the conditions of the limbs as: 1. There is a 8 mm circular penetrating lacerating wound with a 2 mm collar of abrasion, more prominent infero-laterally over the left lateral head, 13 cm from the top and 3.5 cm from the tragus of the left ear. There is a 1.5 cm by 2 cm stellate penetrating laceration wound with everted wound edges over the right parieto-occipital region, 5 cm from the top of the head. 3. Bilateral periorbital hematomas. 4. There is a 7 mm circular penetrating lacerating wound with a 2 mm collar of abrasion over the left posterior chest, 14 cm from the midline and 10 cm below the shoulder line. 5. There is a 1.5 cm by 7 mm irregular penetrating lacerated wound over the left anterior chest, 5 cm from midline, 11 cm below the shoulder line. 6. There is a 6 mm circular penetrating wound with a wide 5 mm crescent of abrasion laterally over the left posterior chest, 4 cm from the midline and 11 cm from the shoulder line. 7. There is a 20 mm by 10 mm gaping penetrating lacerated wound in the right mid-axillary line, 2 cm below the axilla. 8. There is a 15 mm by 9 mm penetrating lacerated wound with a wide collar of abrasion of the left upper limb anteriorly, 18 cm below the right elbow. There is some confluent contusion of the right upper limb associated with this wound. 9. There is a 14 mm by 11 mm irregular penetrating lacerated wound with everted wound edges over the right upper limb posteriorly, 12 cm above the right elbow. 10. There is a 6 mm laceration over the right finger at the second interphalangeal joint. 11. There is a 5 mm laceration over the base of the right thumb, anteriorly at the wrist. 12. There is a 3 mm abrasion over the right wrist, posteriorly, 26 centimeters below the elbow. And 13. There are no ligature impression marks around the wrists or ankles. Captain Gideon Olivier, a ballistic expert attached to the Forensic Services Laboratory, attended the scene prior to the removal of the cadaver on 22 April 2015 and again before the post-mortem examination on the 23rd of April 2015. On the former occasion, he retrieved 3 cartridge cases and on the latter unearthed a spent bullet embedded in the ground directly below where he had observed the deceased's head. From his observations at the scene, the post-mortem examinations and the pathologist's findings, he concluded that the first shot fired at Jade entered her back and exited her chest. The second, that which lacerated the spinal cord and paralyzed her from the waist down, and the third, the shot to the head. Olivier opined that given the trajectory of the latter bullet track, the shooter would have been standing on her left-hand side, with his arm outstretched, pointed in the direction of her head when he fired. It is common cause that gunpowder residue was discovered on the deceased's hand, and the inference can thus properly be made that in her final moments, Jade's outstretched hand entreated mercy. That act of supplication, however, elicited a bullet to her head. The medical and ballistic findings compelled the conclusion that this was an execution-style murder. The discovery of Jade's body and confirmation that she had been murdered reverberated far and wide and evoked a media frenzy. Brigadier Gary Dale McLaren, the provincial head of the East Cape Detective Services based in East London, recounted being contacted by an informant on the Wednesday following the discovery of Jade's body. Although he could not recall the exact date, it is clear that it was the very day upon which Jade was discovered. He duly interviewed his snitch and, accompanied by Colonel Rowan, left East London and proceeded to Cornubushle on further investigation prior to returning to East London. Fortified by the intelligence gathered, he returned to Port Elizabeth the same afternoon, where he met with members of the Directorate for Priority Crime Investigation, the DPCI, and established a task team under the leadership of Captain Reinhard Swanepoel to spearhead the investigation. The breakthrough in unmasking key figures to assist in the investigation occurred on Monday, 27 April 2015, when Captain Willie Mai, the head of the Vehicle Hijacking Division of the South African Police Services in Port Elizabeth, received a call from an informant. It is not an issue that Mai was on investigative duties in Alice when he received the call. He hastened to Port Elizabeth to meet with his informer. This meeting provided the impetus for Mai to search for Sione at his gym, and when he could not be located there, to the home of his girlfriend Babawa Breakfast, and thence to the Infinity Club. Sione's involvement in the conspiracy to murder Jade was extensively expounded upon in the summary of substantial facts, which, juxtaposed alongside the plea explanation, established that he is, paradoxically, the nucleus of accused number one's defense and a key witness for the state. Given his centrality to accused number one's defense, it is apposite to consider the legitimacy of the quest to have his testimony determined as a separate issue, colloquially referred to as a trial within a trial. The contention that it be so determined was vigorously pursued by both Mr. Price and Mr. Doberman in argument before me. I interpolate to say that although counsel for the state was initially seduced by the superficial attractiveness of the proposed course, overnight deliberation exposed its flaws, and he opposed the application. As I shall elaborate upon, it is unprecedented, an exercise in opportunism, and a disingenuous attempt to exclude otherwise admissible testimony. I dismissed the application and indicated that my reasons would be incorporated in the judgment, and these now follow. A trial within a trial is, as Stryker J. trenchantly alluded to in Director of Public Prosecutions v. Transvaal v. Viljoen, a trial held while the main trial is in progress in order to determine a factual issue separately from the main issue. The factual issues contended for by the defense was the voluntariness of Sione's testimony, inclusive of his extracurrial statements and pointings out to various officers. The gravamen of their attack on its admissibility is the contention that Sione's fundamental rights were violated to such an extent that all the evidence consequentially procured is inadmissible against the accused. Leaving aside for a moment the question whether Sione was in fact tortured as alleged, a matter as I shall in due course consider, the fallacy of the argument advanced is the conflation of Sione and an accused person. Sione is, notwithstanding his designation as such by both Messrs. Price and Doberman, not an accused person. He is a state witness whom counsel for the state intimated when called to the witness stand that he be warned pursuant to the provisions of Section 204 of the Criminal Procedure Act. In his address, counsel for accused number 1 was, given the excogitated nature of the application, constrained to concede that the absence of any authority for the submissions advanced. The raison d'etre for the dearth thereof is evidence. It is a procedural device available only to an accused person and no other. A succinct exposition of its genealogy was articulated by Nicholas A.J.A. in State v. De Vries, 1989, 1 SA 228A at 2328 to 234A as follows. Section 2171 of the Criminal Procedure Act 51 of 1977 provides for the admissibility of evidence of a confession made by any person in relation to the commission of any offence if such confession is proved to have been freely and voluntarily made by such person in his sound and sober senses and without having been unduly influenced thereto. There had been similar provisions in Section 2731 of the Criminal Procedure Evidence Act 1917 and in Act 56 of 1955. In R v. Gumedi and another, 1942 AD 398412-413, Freetham J. mentioned that the provision first appeared in South African legislation as part of Section 28 of the Cape Ordinance 72 of 1830 and added, "There can, I think, be no doubt that the proviso was included in the 1830 Ordinance was intended to apply to the Cape Colony, the common law of England as then understood, in regard to the burden of proof resting on the prosecution when asking a criminal court to admit a confession alleged to have been made by an accused person. The rule of the English common law had by 1830 become well established and was of long standing. See Gumedi's case supra at 413 in Finn. It was described by Innes C.J. in R.V. Barlin, 1926 AD 459 at 462 as, the common law allows no statement by an accused person to be given in evidence against himself unless it is shown by the prosecution to have been freely and voluntarily made in the sense that it has not been induced by any threat or promise proceeding from a person in authority. The rule is a rule of policy. In Gumedi's case supra at 413, Freetham J.A. quoted from the judgment of Lord Sumner in Ibrahim v. R. 1914 AC 599 at 610, a confession forced from the mind by the flattery of hope or by the torture of fears comes in so questionable a shape that when it is to be considered as evidence of guilt that no credit ought to be given to it. Briggs v. Warwickshire, 1873, 1 Leach, 263. It is not that the law presumes such statements to be untrue, but from the danger of receiving such evidence, judges have thought it better to reject it for the due administration of justice. If the policy is to be effectuated, it is of primary importance that an accused person should feel completely free to give evidence of any improper methods by which he alleges a confession or admission has been extracted from him. Unless he gives evidence himself, he can rarely challenge its admissibility. See the judgment of Lord Hailsham in St. Mary Lebone in the Privy Council case of R.V. Wong Kam, 1980 AC 247 PC at 261B to C. Any civilized system of criminal jurisprudence must accord to the judiciary some means of excluding confessions or admissions obtained by improper methods. This is not only because of the potential unreliability of such statements, but also, and perhaps mainly, because in a civilized society, it is vital that persons in custody or charged with offences should not be subjected to ill treatment or improper pressure in order to extract confessions. It is therefore of very great importance that the courts should continue to insist that before extrajudicial statements can be admitted in evidence, the prosecution must be made to prove beyond reasonable doubt that the statement was not obtained in a manner which should be reprobated and was therefore, in the truest sense, voluntary. For this reason, it is necessary that a defendant should be able and feel free, either by his own testimony or by other means, to challenge the voluntary character of the tendered statement. It is accordingly essential that the issue of voluntariness should be kept clearly distinct from the issue of guilt. This is achieved by insulating the inquiry into voluntariness in a separate compartment from the main trial. In England, the inquiry into voluntariness is made at a trial on the voir dire, or simply the voir dire, which is held in the absence of the jury. In South Africa, it is made at a so-called trial within a trial. Where, therefore, the question of admissibility of a confession is clearly raised, an accused person has the right to have that question tried as a separate and distinct issue. At such trial, the accused can go into the witness box on the issue of voluntariness without being exposed to general cross-examination on the issue of his guilt. The prosecution may not, as part of its case on the main issue, lead evidence regarding the testimony given by a defendant at the trial. It will be gleaned from the aforegoing, and in particular the highlighted portion of the quoted judgment, that the procedure is available only to an accused person. Sione is, despite assiduous clamour by the defence representatives, not an accused person. The fact that he had been arrested and initially charged with Jade's murder is entirely irrelevant. He is a state witness, cadet quaestor. Dismissive of my ruling that the proposed procedure was ill-conceived, Mr. Doberman nonetheless launched a fresh application the following morning, contending that authority vouchsafed the granting of the application. Neither the cases nor the journal article cited established the principle contended for, and I dismissed the renewed application. The attempt to persuade me to revisit my earlier ruling was misguided and to be deprecated. The rationale for the concerted endeavour to exclude Sione's testimony from the conspectus of evidential material soon manifested itself. As presaged in the summary of substantial facts, the state's case was that Sione was intimately involved in securing the assassin, and it was evident from the factual matrix encapsulated therein that it constituted inter alia a précis of his statement or statements to the police. Its acceptance prima facie heralded dire consequences for the accused, and in particular accused number one, and the stratagem devised for its exclusion obviously required his collusion. The full extent of his connivance soon manifested itself, as I shall advert to hereafter. It is abundantly clear, notwithstanding the gratuitous imputations levelled against Mr. Stander, that the latter had been deceived into believing that he would adhere to the content of his statements to the investigating officer Swanepoel. This appears clearly from the concluding email from his attorney, Mr. Neza, to Stander on 4 October 2016. The aforementioned email and a raft of earlier missives was introduced into the trial by Mr. Price during his ostensible cross-examination of Sione. Although it is permissible to put leading questions during cross-examination, no weight whatsoever can be attached to any of Sione's affirmative responses. The cosseted questioning, designed to establish that Sione was not the author of the content of the statements to Swanepoel, which bore his signature, and his acquiescence in the insinuation that counsel for the state had, notwithstanding knowingly called him, established the extent of Sione's collusion with accused number one. As for Neza, the least said about him the better. His advice to Sione that he should not answer any incriminating questions is in direct conflict with legal precedent. As Ackerman J. remarked in Nell v. LaRue, Eno and others, and I quote, in view of the transactional indemnity and use immunity provisions in Section 204, 2 and 4 of the Criminal Procedure Act, the applicant could not validly and did not object to answering self-incriminating questions. It is apparent from the last email from Neza to Counsel for the State, 4 October 2016, wherein he stated, and I quote, "Our client remains a Section 204 witness and does not have any intention to deviate from such unless your office reject him as such," close quotation, that Mr. Stander was thereby duped into believing that Sione would testify in conformity with the version chronicled in his statements. Subsequent events soon established the extent of the collusion not only between himself, Breakfast, and those family members called to corroborate his version, but it moreover compels the conclusion that Neza was party to the deception practiced on the prosecution. It is common cause that in consequence of information obtained, Mai, after a fruitless search for Sione at his home, and Jim departed to Breakfast's home where, after interviewing her, she accompanied him and directed him to Infinity, where Sione was taken into questioning prior to them being taken to the KwaNobuhle detective officers. Although Breakfast would later decry having deposed to written statements to Mai, her denial is patently false. Her revelations to Mai validated the information obtained from his snitch, and I accept that when later confronted therewith, Sione admitted his complicity in the conspiracy to murder Jade. Mai's evidence concerning the amiable interaction between himself, Breakfast, and Sione required remedial action to conform with the version advanced by accused number 1 in his plea explanation, and Breakfast's cross-examination by Mr. Price was thus structured to achieve that result, as appears from the following extract from the transcript, and I quote, "On the 27th of April, when the police came to your house, that was Captain Mai and other police officers correct? That is correct, sir. And you have told us that it was decided that one of your brothers will go with you, and if I understand you correctly, it was to ensure that you were okay, that you were safe. That is correct, sir. And can I accept that you wouldn't have been comfortable to go with these police officers if your brother wasn't allowed to go with you? Yes, my lord, because those people were unknown to me, and I saw them for the first time that evening. Now, my understanding of the evidence is that you weren't asked to accompany them, you were ordered to accompany them. They came in, they said they were looking for Babalwa. Pardon. Yes, listen carefully. I am not fighting with you, just listen carefully. I am saying to you, they didn't ask you nicely if you would go with them. They told you, come with us. My mother responded to them, and then I got up. Yes, I don't think you are listening to me. Would you have gone if they hadn't told you to go with them? Let me ask you that. No, my lord. You felt you were obliged to go with them because they said they wanted to ask me some questions. Listen carefully, listen carefully. You went because you didn't go because you wanted to go. You went because they told you to go. Yes, my lord. It will be gleaned from the aforegoing that the assertions made to Breakfast, and which were subsequently put as a fact to Mai, did not emanate from Breakfast at all. Her acquiescence in the propositions put to her by Mr. Price clearly establishes her partisanship and compels the conclusion that she had been suborned to recount her police statements. As adverted to in the preceding paragraphs, during Mai's cross-examination, this erroneous rendition of the true facts was perdured with by the following proposition put by Mr. Price. So you will not dispute her evidence in this court that she feared you and your group, and it was a decision to take her brother with so that he could look after her best interests. And later, now could you just explain to me why you took Babalwa's brother back to the house before you went to KwaNobuhle? There was no reason. I just took him back home because we found Tando home. We went to look for him at Algoa Park. Yes, but Bababa was going to show you where Tondo was. Why did you take her brother back? Her brother had nothing to do with this at all. Of course, except he might have been a witness to you beating people up and threatening people. That is why he was taken back. No, I don't think so. If we were aware that we would also require a statement from him, we would have taken him along, but because he had nothing to do with the case at that stage, that is why he was dropped off at his home. Well, Bababa told this court that she wanted him there as protection for herself and that she was unhappy when you dropped him back at home. She wanted him to go with them to wherever you were going. I hear this for the first time here in court because she never ever requested her brother to be taken along to KwaNobuhle or display any discontent by the fact that he was dropped off at home. It was your decision to drop him off. That is correct, sir. I did inform Bababa that we are going to drop off your brother now. It became clear during breakfast evidence in chief that she had recanted her police statement, a fact confirmed by counsel for the state. Thus, as a precursor to requesting that she be declared hostile, Mr. Stander, having established that her signature was indeed appended to each of the police statements, Exhibits V25 and V26, proceeded to question her therein. In response to a question as to the circumstances under which she signed the statements, she proffered the answer that she was merely given a piece of paper to sign and duly complied with the instruction. To prove that she was indeed the author of the statement, Mr. Stander proceeded to read the statement to her to elicit her confirmation. The regurgitation of the statement, sentence by sentence, yielded the stock answer that its content did not emanate from her. I interpolate to say that Mai was subsequently called to testify that he minuted both statements which she signed in his presence. The procedure adopted by Mr. Stander finds legislative sanction in Section 190 of the Criminal Procedure Act. It provides as follows. 190. Impeachment or support of credibility of witness. 1. Any party may in criminal proceedings impeach or support the credibility of any witness called against or by or on behalf of such party in any manner in which and by any evidence by which the credibility of such witness might on the 13th day of May 1961 have been impeached or supported by such party. 2. Any such party who has called a witness, who has given evidence in any such proceedings, bracket, whether that witness is or is not, in the opinion of the court, adverse to the party calling him, close bracket, may, after such party or the court, has asked the witness whether he did or did not previously make a statement with which his evidence in the said proceedings is inconsistent, and after sufficient particulars of the alleged previous statement to designate the occasion when it was made have been given to the witness, prove that he previously made a statement in which such evidence is inconsistent. When counsel for the state solicited the details surrounding the money found in Sioni's gym bag and which were encapsulated in Exhibit V25, it triggered a marked attitudinal change in breakfast and, as the further questioning unfolded, her demeanor indicated open hostility towards the prosecution. The inference can thus properly be made that she had misled counsel for the state into believing that she would testify in conformity with her police statements. Her deception, attitude, and behavior demonstrated her implacability, and a declaration of hostility seemed meet. I interpolate to say that the objection raised by Mr. Doberman to my declaration is without any merit whatsoever and requires no further elucidation. Under cross-examination by Mr. Stander, it became abundantly clear that her denial of being the author of the statement's contents is patently false. I accept that she was the source of the information recorded in Exhibits V25 and V26. I shall in due course, in conjunction with Sioni's extracurrial statement, determine their probative value, but proceed first to the aftermath of her revelations to Mai. It is not an issue that Sione was interrogated at the corner Bushley detective offices by Mai. In his evidence in chief, Sione described the assault perpetrated upon him by Mai and a number of other policemen as, and I quote, torture. It is unnecessary to delineate the nature and extent of the alleged battering for the simple reason that his evidence is, upon a holistic appraisal of the evidence, a cocktail of lies, perjury and contrivances designed to advance accused number one's defense. While it is correct that Sione's eye was swollen, I accept Mai's testimony that the injury was sustained during the scuffle when Sione resisted being handcuffed. It is highly improbable, given the unprecedented outcry and media frenzy which accompanied Jade's murder, that Mai or any other member of the initial investigation team would have been so foolhardy to jeopardize the investigation by perpetrating an assault on Sione, particularly in light of the revelations by Breakfast of his direct involvement. The probabilities favor Mai's version that after being confronted with Breakfast's revelations, Sione admitted his complicity in Jade's murder and directed the police to various places where the money was eventually retrieved. In his address, Mr. Price submitted that Sergeant Nedi Gukamana did not support Mai's version and that an adverse inference should be drawn from the failure to call the policemen who were present on the night in question. That fact that Gukamana was unable to recall having heard Sione consenting to point out the money does not avail the defense. The import of his evidence fully corroborates Mai's, and there was accordingly no need for the state to call supererogatory witnesses. The fact that he thereafter exclaimed having been assaulted amounts to sheer opportunism and merely establishes his guile. The injury provided the visible manifestation of his claim and was a mechanism whereby he could subsequently impugn Mai's credibility and seek to avoid the consequences of his admissions to him. A classic example of his penchant to prevaricate and lie occurred when questioned about the money found in his gym bag later that evening. It elicited a convoluted, prolix explanation that it was money entrusted to accused number one for safekeeping, which he had retrieved to recompense Sizwake Zumazonke, who had sourced weights for his gym. That account of its derivation corresponded in broad outline with Breakfast's viva voce explanation tendered prior to her being discredited, and remarkably also broadly conforms to accused number one's plea explanation as to its source. At the conclusion of the hearing on that day, i.e. Friday, 11 November 2016, that remained his version. Sione's weekend sojourn at the awaiting trial cells had a profound effect on his powers of recollection. When he was recalled to the witness stand on Monday morning, 14 November 2016, he made a complete volte-face and stated that the money was the pilfered portion of the 80,000 rand he had received from accused number one destined to Vomazonke as payment for Jade's contract killing. This veracious account of the source of the 31,000 rand accords with Breakfast's narrative in her police statements V25 and V26, albeit that she had not on her version counted the money which she placed in the socks. Arithmetically, it amounted to 31,000 rand. As I shall in due course further detail, Sione's evidence is, with one exception, i.e. the 80,000 rand, fabricated and false to be rejected. His malleability was most pronounced during his ostensible cross-examination by Mr. Price. Having been suborned to recant his extracurrial statements, his acquiescence in the plethora of leading questions put to him accentuates the deception whereby he inveigled the prosecution into calling him as a witness. This is best illustrated when, after being cajoled into validating Breakfast's claim to blindness, he readily assented to a multitude of propositions inter alia that he had not only been assaulted, browbeaten into submission, forced to accompany the police to search his home and the place where the 31,000 rand was recovered, ill-treated but forced to append his signature to prepared statements. Whilst it is correct that the right of full cross-examination includes the employment of leading questions, the weight of the evidence thus procured is minimal where, as here, Sioni's partisanship is glaring. I accept that the true account of what transpired between accused number 1 and Sioni is the version encapsulated in the statement Exhibit AY1, which he deposed to Swanepoel on 3 May 2015. The same considerations apply to Breakfast's statements to Mai on the evening of 27 April 2015. Notwithstanding the fact that the content of Exhibit AY1 was extensively covered with Sioni when cross-examined by Mr. Stander, and the document handed in as an exhibit, an objection was raised when a portion of its content was canvassed with Ms. Chanel Kutz during her cross-examination. The contention that the statement has not been proved is spurious. When Swanepoel was led, he detailed the circumstances which led to him minuting the statement, adverted to the meeting between Sioni's then attorney Van der Spey and the eventual signing of the statement by Sioni. Swanepoel's evidence that Sioni appended his signature to AY1 proves that he made it. The question whether the contents of the aforementioned statements, which, as I have adverted to, were disavowed by both Sioni and Breakfast when they were called to testify, constitute admissible evidence, has received the imprimatur of the Supreme Court of Appeal in State v. Ratumba, 2012, 2 SACR 219 SCA at para 10. Such evidence is, as the Court correctly categorized, hearsay evidence. Its reception is regulated by Section 3.1 of the Law of Evidence Amendment Act, which provides as follows. 1. Subject to the provisions of any other law, hearsay evidence shall not be admitted as evidence at criminal or civil proceedings unless a. Each party against whom such evidence is to be adduced agrees to the admission thereof as evidence at such proceedings, b. The person upon whose credibility the probative value of such evidence depends himself testifies at such proceedings, or c. The court having regard to 1. The nature of the proceedings, 2. The nature of the evidence, 3. The purpose for which the evidence is tendered, 4. The probative value of the evidence, 5. The reason why the evidence is not given by the person upon whose credibility the probative value of such evidence depends, 6. Any prejudice to any party which the admission of such evidence might entail, 7. Any other factor which should, in the opinion of a court, be taken into account is of the opinion that such evidence should be admitted in the interests of justice. In holding that the evidence of the witnesses who had disavowed their police statements had been properly admitted in evidence by the trial court, the Court of Appeal reasoned as follows, and I quote, Section 3 enjoins a court in determining whether it is in the interests of justice to admit hearsay evidence, to have regard to every factor that should be taken into account, and more specifically to have regard to the factors mentioned in Section 3.1c. This court in State v. Ndlovu and others, 2002 SACR 325 SC8, considered the provision of Section 3 and at paragraph 31 held, and I quote, the probative value of the hearsay evidence depends primarily on the credibility of the declarant at the time of the declaration, and the central question is whether the interests of justice require that the prior statement be admitted, notwithstanding its later disavowal or non-affirmation. And though a witness's disavowal of or inability to affirm the prior statement may bear on the question of the statement's reliability at the time it was made, it does not change the nature of the essential inquiry, which is whether the interests of justice require its admission. In amplification in paragraph 33, it was stated that The probative value of the accused statements to the police did not depend on their credibility at the time of the trial, which the court rightly found totally lacking, but on their credibility at the time of their arrest. And the admissibility of those statements depended not on the happenstance of whether they chose to testify, but on the interests of justice. This is precisely the type of case where the interests of justice imperatively call for the admission and substantive use of the statements of both Sione and Breakfast as admissible evidence. In her statement to Mali, Exhibit V25, Breakfast recounted the events as follows. Somewhere between January and February 25, when I was at Tando's place and we were in his room that is situated outside the main house. While we were in the room, Tando informed me that he had been approached by his employer called Chris. According to Tando, Chris wanted to kill his wife, and he told him that he could not do that, but he can organize people that can do that for him. Soon after that, Tando told me that he tried to organize people from Zweden and New Brighton, but they all failed him. But I am not sure of the date. Tando has again informed me that he has found a guy that he called Sizwe who told him that he will kill the lady for him. According to Tando, the person that could successfully do the job for Chris would be paid an amount of 50,000 rand. I did not see the said Sizwe that promised to kill the lady for Tando and Chris. The said lady was said to be the wife to Chris, but I did not know or was never told as to what the reason of the killing was. On Monday night, 24:15, I'm not sure of the time, I was at Tando's room with him when he received a call on his phone. The caller told him that we have finished this and we want our money. After that call, Tando waked up and went outside. As I was hearing what was being said, I then decided to take his phone and to see who was calling him. On paging the phone, I noticed that the caller was Sizwe, who was saved on his phone as Sizwe. After that, he came back and joined me on the bed. After that, Chris, the employer of Tando, arrived there driving a double cab bakkie. I think that the color is silver grey and that he did not come into the house, but Tando went out to attend him. After that, Tando came back telling me that I must phone my brothers, Mabuti and Toto, to come and fetch me at his place. Tando and Chris have then left me there waiting for my brothers. At about 2300 hours, my two brothers arrived and we walked home. I then met Tando the following morning when he came to my place. He phoned me to meet him outside. On meeting him, he told me that he did not get the money from Chris, that he did get the money from Chris to pay Sizwe. I would like to state that on arrival of Chris, first before he went out with Tando, Tando came back from Chris and had a black bag that had money in it. He then requested me while waiting for my brothers, I must please count 50,000 rand out of the money in the bag. I did not count it. I then placed the said 50,000 rands in the bag and kept the other one side. I was then told by Tando that I must take the money, I must then take the bag with the 50,000 rand, and I did that. While I was sleeping at home, Tando phoned me to meet him outside with the money. I then took the bag and went outside. It is then that I noticed that he was driving with Sizwe in Sizwe's white car that he used to drive. I then went to bed again. That is all I know of that incident. At the time Mai minuted the statement from Breakfast, there was a dearth of information surrounding the death of the deceased, and the suggestion that Mai was the author of Exhibit V25's content is nonsensical. The attention to detail and the identification of key players attests to Breakfast's truthfulness at the time of making the statement. It is apparent from the foregoing detailed exposition that Sione, having been appraised of Breakfast's revelations to Mai, would, as Mai testified, have realized the quandary he was in and set in motion a process to broker a deal with the police and the prosecuting authority. In his Section 204 statement, he narrated the circumstances under which he began employment with accused number 1 and the approach made to him by the latter to find an assassin and his attempts to do so. He then narrated its sequelae as follows. Later that year, about August, September, October 2014, while I was on duty, Chris asked me to accompany him to his vehicle. As we were nearby his vehicle, he asked me if you knew someone who can, and then he made a sign with his hands across his throat, which meant to me that I knew someone who can kill someone. I remember that this conversation could not take place next to the car or inside the car, as Chanel was already sitting in the car. I replied that I will look for someone. Nothing further was discussed. I did not know at that stage who was to be killed. I then started to look for someone. I was interested in this plan as I believed that there was financial gain in it for me. I first went to a guy that I know by the name of Lama of Motherwell. I believed that Lama himself would not kill the person, but was hoping that he would know someone. I told Lama that my boss was doing the request. I was not supposed to tell Lama that it was my boss, as Chris requested me not to do so, as he wanted to protect his identity. Lama requested a meeting with Chris. A few days later, I introduced Chris to Lama. We met nearby the Dunkirk Stadium in the parking area of Kabani Tavern. I was not allowed to listen to the conversation, as Chris instructed me to wait outside the car. Lama was evading me after this meeting, and I did not spoke to him afterwards. Nothing came of this Lama-Chris meeting. Chris then started to put me under pressure to find someone else. I then went to another person I knew, Trumpy. I also know Trumpy as a person who would not kill the person himself, but would get someone to do the job. Trumpy was interested in the proposal. He also requested to meet with Chris. I arranged a meeting between them, and they met at Infinity. I was not present when the discussion took place. This meeting with Trumpy took place about 2 weeks after the meeting with Lama. The result was about the same as with Lama. Nothing came from it. Chris was putting me under more pressure. This was the first time he told me that the person he wanted to be killed was indeed his wife. He told me that it must happen before the school holidays, because once the school holidays began, it would not be as easy, as his wife would not be as easy to be found. The only reason he explained to me was that his wife spent too much money, while he, that is Chris, must work long hours for his money. He furthermore told me that a vehicle he had, a Renault Megane, which he had to sell because of financial problems. He told me furthermore that he then had to fix the double cab bucky and then sell it. He said that he then sold it for 50,000 rand and paid the money to the bank. Therefore, this vehicle deal thing resulted in a huge financial loss for him. Furthermore, he told me either his parents or his wife's parents was forcing him to buy a home when he did not want to do so. He became more adamant by the day to find someone to do the killing of his wife. I then tried another person by the name of Andile or S. He just came out of prison at the time. I met him and he colored friends. But nothing came from this, just as the case with Lama Trumpy. The school holidays had long since passed until February this year, 2015. I met a person, Sizwe Vumazonki, I knew in Goko's Tavern. I knew Sizwe from Club 9 Yards. I knew that he knew people who could do the job. He was approached in the same way I approached the other people. He said that he was interested in the job, and we exchanged numbers. He would then contacted me later. A few days later he contacted me. We met at Infinity a few days later. I was supposed to show him the places where he could find Chris's wife. Sizwe told me that he would come tomorrow. He did come that tomorrow. At that time Chris had already showed me where he stayed. The next day Sizwe did turn up, and I went to show him. It was going now towards March. Sizwe disappeared. I was back to square one now. I started looking for other persons again. At this time, Chris was almost panicking. I made contact with my neighbor at the gym, a guy called Touch. He introduced me to Cadets. However, nothing came from this again as a result of finance. I contacted Sizwe on Facebook and informed him that the prize for the hit was not 40,000 rand. He replied that I must SMS my number to him, which I did. A few days later, Sizwe pitched up at my gym. He requested me that I must inform the two persons what was going on, and I did just that. The persons wanted a rented car to do the job. I then phoned Ntando's car hire. I phoned on my phone, and the amount was 6,000 for the rented vehicle. I borrowed money of 1,500 rand and gave 1,500 rand of my own money, and Chris eventually came and dropped 3,000 rand at the gym. I then handed the 6,000 rand to Sizwe. This was early April 2015, just before the schools opened. The vehicle was a white Toyota small car. A plan was put in motion. The plan was for Chris to bring his wife for a Sunday dinner to Infinity in the car. I would have been at the place where I would then show the vehicle, a Fiesta white in color, to Sizwe and his friends, from where they would then follow her, as they could not kill her in front of the club. The plan was, however, cancelled, as the wife did not want to come to Infinity. Chris then decided to show me another possibility where she could be taken out. The possibility he showed me was the friend's home with whom she was driving. The school opened the Monday after the holiday. I learned from Sizwe that they wanted to do the job that one of the mornings and followed her. As it was raining and was bad weather, they did not succeed. By that time already, I had shown Sizwe one night where the lady friend stayed. I also provided Sizwe with the vehicles of a registration number, which I got from Chris. The information that she was driving, I got from Chris. Because Sizwe did not succeed that week, Sizwe came back to me requesting that I must ask Chris to let him into the complex and the home. Chris replied that he could not do that, as the complex was too secured and that a policeman was staying opposite him in any case. He would not be able to answer all the questions. Chris insisted that it must look like a robbery outside the gate or a hijacking. As Sizwe's plan could not work according to Chris, he told me that he will make another plan.
Well, that's judgment on the Christopher Panayiotou case. Now we'll go back there.
I got a call from Sizwe telling me the job was done and that he wants his money. I then went on foot to Infinity. The arrangement that stood from the previous week with regards to the money was that I would collect it from the office. There was an arrangement that Chris would leave the money with Knox. When I got to Knox, there was no money. I did not phone Chris, as I did not want any telephonic link with him. While I was with Knox, the news broke on Facebook that Chris's wife was missing. I went outside and phoned Sizwe, informing him that I could see what he told me was true. I also informed him that I was looking for money from Chris. That whole day I received only one call from Chris. He was using Infinity's landline number. He did not say much, as you could hear that he was with people. I eventually went home. That night I went to sleep with my girlfriend at my home. That night, very late, I got a call from Chris. He asked me where I stayed, and I met him in Tongeni Road. I got into his car, his white Golf. Once inside the Golf, he asked me where the guys put her. I could not answer that question. He gave me a plastic bag containing money when we were in front of my house. I went inside my house. I gave my girlfriend the plastic bag and left again. I got into Chris's car and we drove. We were driving around looking for possible suspects. We met with some of his family friends at KFC in Jewelry Square. He took me to Babalwa's, my girlfriend's house. I have instructed earlier for Tato, Babalwa's brother, to fetch Babalwa, and we would meet at Babalwa's house. We then counted the money for Sizwe. It was 40,000 rand. The time now was about 1 o'clock, 0100, on Wednesday morning. I told him that he can come and fetch his money. I left the money with Babalwa and walked home. Minutes later, Sizwe stopped at my home. He hooted for me and I went outside. I saw that it was Sizwe. I got into the car and we drove to Babalwa's house. At Babalwa's house, I knock and she opens the door. At the time, Sizwe was standing at the back of me. Babawa brought the money to the kitchen door. Sizwe greeted Babawa. Myself and Sizwe then drove to KFC in Jolly Square, where I bought KFC, then took me home. Sizwe told me earlier that he did not do the job with the people I had met with, that he did not do the job with the people I met him with earlier. Sizwe informed me therefore that I should meet with those guys and I should tell them Sizwe did not went ahead with the job. On the Friday, Sizwe called me telling me that the people who did the job wanted more money. He was now driving another car, not the white Toyota anymore. I conveyed the message to Chris. Chris later told me to get rid of my cell phone and SIM card. He gave me 1,000 rand to replace my cell phone and SIM card. I took the money but did not destroy the cell phone and SIM card. On Sunday, the 26th of April 2015, I was arrested and I made a confession. It became clear to me that I was in deep trouble and decided to cooperate with the police. On request, I made a few telephone calls to Chris, which resulted in a meeting in a vehicle that I was told would have been recorded. This statement was made in the presence of my lawyer. That is all I can declare. The lawyer referred to in the preceding paragraph of the aforementioned statement was Van der Spy, an attorney attached to the local justice centre. During this trial, his integrity was assailed by Mr. Price. The besmirchment of his character is scandalous and merits this court's opprobrium. I accept Swanepoel's testimony that he enlisted Van der Spy's professional assistance to assist Sione, and that the latter's disavowal of having been properly advised by him is false. Sione's admission that accused number 1 had orchestrated Jade's murder finds further corroboration from the most unlikely source, accused number 1 himself. In the anti-penultimate paragraph of his Section 204 statement, Sione adverted to a meeting in a vehicle with accused number 1. It is common cause that it took place during the evening of 29 April 2015 outside a Steers fast food outlet in an unmarked police vehicle equipped with listening and filming devices, and that their conversation and interaction had been recorded in both audio and video format. This activity finds legislative sanction in Section 252 capital A of the Act. Under the rubric, authority to make use of traps and undercover operations and admissibility of evidence so obtained, it provides as follows. 1. Any law enforcement officer, official of the state or any other person authorized thereto for such purpose, hereinafter referred to in this section as an official or his or her agent, may make use of a trap or engage in an undercover operation in order to detect, investigate or uncover the commission of any offence or to prevent the commission of any offence, and the evidence so obtained shall be admissible if that conduct does not go beyond providing an opportunity to commit an offence, provided that where the conduct goes beyond providing an opportunity to commit an offence, a court may admit evidence so obtained subject to subsection 3. Subsection 3 in turn provides that, and I quote, if a court in any criminal proceedings finds that in the setting of a trap or the engaging of an undercover operation, the conduct goes beyond providing an opportunity to commit an offence, the court may refuse to allow such evidence to be tendered or may refuse to allow such evidence already tendered to stand if the evidence is obtained in an improper or unfair manner, and that the admission of such evidence would render the trial unfair or would otherwise be detrimental to the administration of justice. B. When considering the admissibility of the evidence, the court shall weigh up the public interest against the personal interest of the accused, having regard to the following factors, if applicable. 1. The nature and seriousness of the offence, including AA, whether it is of such a nature and of such an extent that the security of the state, the safety of the public, the maintenance of public order, or the national economy is seriously threatened thereby. BB, whether in the absence of the use of a trap or an undercover operation, it would be difficult to detect, investigate, uncover, or prevent its commission. CC, whether it is so frequently committed that special measures are required to detect, investigate, or uncover it, or to prevent its commission. Or CC, whether it is so frequently committed that special measures are required to detect, investigate, uncover, or to prevent its commission. Or DD, whether it is so indecent or serious that the setting of a trap or the engaging of an undercover operation was justified. 2. The extent of the effect of the trap or undercover operation upon the interests of the accused, if regard is had to AA, the deliberate disregard, if at all, of the accused's rights or any applicable legal or statutory requirements. BB, the facility or otherwise with which such requirements could have been complied with, having regard to the circumstances in which the offence was committed. Or CC, the prejudice to the accused resulting from any improper or unfair conduct. 3. The nature and seriousness of any infringement of any fundamental right contained in the Constitution. 4. Whether the setting of the trap or the engagement of an undercover operation, the means used was proportional to the seriousness of the offence. And 5. Any other factor which, in the opinion of the court, ought to be taken into account. Thus, as a precursor to adducing testimony to prove the admissibility of the evidence so obtained, Mr. Stander requested that I order that a trial within a trial be held to determine the issue as provided for in subsection 7. Mr. Price, whilst of the view that he was, and I quote, not entirely ad idem as exactly what the grounds are for the trial within a trial, close quotations, was constrained to concede that in terms of the directory language of section 252A capital A7 of the Act, it would, and I again quote, preferable to determine the issue in a trial within a trial, close quotation. The subsection provides as follows. 7. The question whether evidence should be excluded in terms of subsection 3 may, on application by the accused or the prosecution, or by order of the court of its own accord, be adjudicated as a separate issue in dispute. Notwithstanding the ambivalent stance adopted by Mr. Price regarding the procedural device for determining the admissibility of evidence uncovered during the undercover operation, it is implicit from the terms of the section, however much its directory language, that where such evidence is sought to be excluded, the appropriate avenue to determine admissibility is the procedure contemplated by subsection 7. This approach was specifically endorsed by the Supreme Court of Appeal in State v. Matsabo, 2009 1 SACR 513 SAC as follows. Some point was made in the heads of argument about the magistrate's refusal to hold a trial within a trial when his legal representative twice objected to the admissibility of the trap evidence and asked that admissibility be tried as a separate issue. During argument, reliance on that ground was all but abandoned. Such uncertainty as remains should be dispersed. Our courts have long accepted that it is both desirable and necessary to the end of achieving a fair trial to try issues of the voluntariness of extracurrial statements or conduct of accused persons separate from the merits of the case. R.W. Dunga, 1934 AD 223. When a ruling is made without hearing the defense evidence, the defense is entitled to withhold its further testimony where it could only be given on terms which may prejudice the trial on the merits. In general terms, section 252 capital A is also concerned with the voluntariness of conduct as the measure of whether an accused's conduct is induced by the circumstances of or methods employed in the operation rather than resulting from his own desire to commit the offence. In principle, I do not think that there is any material distinction between the accepted categories of cases where the separation of admissibility and merits is insisted upon and Section 252 capital A. Both inquiries seem to take account of and provide for the same inherent risks, such as discouraging an accused person from speaking openly when the trial of the merits may be influenced, if he does so, and the likelihood that failure to deal with admissibility properly and promptly will leave an accused in limbo in relation to the vital questions of whether he needs to testify and the substance of the case he has to answer. So also the prosecutor must know the limits of his case, both for the purpose of leading further evidence and for cross-examination of the accused. For all these reasons, the holding of a trial within a trial will usually be appropriate to decide admissibility under 252A. We'll take the tea adjournment now. We'll start again at 11:15.
Court.
Consequently, where a trial within a trial is so ordered, the proviso to subsection 6 obliges an accused person, in peremptory terms, to furnish the grounds upon which the admissibility of the evidence is challenged. In response to a direct question by me herein, Mr. Price stated as follows, and I quote, "It is difficult for me to address you on that, particularly because it is not our view that section 252 capital A is applicable here, but in short, I think if you look at our plea explanation, what we have said all along, we say that our client's right to a fair trial was decimated ab initio, and this is just part of that decimation. In other words, I think that is about as clear as I can put it to your Lordship. We are relying very strongly, my Lord, as you know, on the Mtembu and Tandwa cases. This nuanced response limited the admissibility challenge to the alleged assault on Sioni and a fortiori, a violation of the accused's fair trial rights. After the adduction of evidence by the state, the accused elected not to testify, but called 3 witnesses, Sioni's mother, brother, and the mother of breakfast. It was, however, agreed upon by the state and the defense that in determining admissibility I could have regard to the testimony of Sioni and breakfast. It is trite law that during a trial within a trial, the court is entitled to have regard to evidence already led in the made trial. See State v. Muchindu, 2002, SACR 313W at A to C. After hearing argument, I ruled that the video and audio recording between accused number 1 and Sioni was admissible in evidence against accused number 1 and intimated that my reasons would be incorporated in the judgment. These now follow. The decision to engage in the undercover operation was engendered by the interview Swanepoel had with Sioni on 28 April 2015 at the Directorate of Priority Crimes, the unit's offices. It is common cause that by then, Swanepoel was in possession of Sioni's confession made to the magistrate the previous day. The state's version of the events which unfolded during and after the interviews he had conducted with Sioni on 28 and 29 April 29 is, upon an appraisal of the evidence adduced, the only credible factual account of the circumstances which ultimately led to the meeting between accused number 1 and Sioni on the evening of 29 April 2015. Swanepoel's testimony is corroborated in all material respects by his underlings, Warrant Officer Shane Bosch, Warrant Officer Leon Eckstein, Sergeant Andre Kuhn, and the unit's head, Brigadier Till. Accused number 1's version, on the other hand, was confined to the concurring affirmations by Sioni to a raft of propositions put to him by Mr. Price. This appears clearly from the following exchanges with Mr. Price, with reference to the transcript of the recorded conversations between Sioni, accused number 1, and the members of the unit during 28 and 29 April, Exhibit BG5, put the following scenarios to Sioni. Now I'm just going to summarize very quickly what our case is on the 28th, what happened at organized crime on the 28th, and we are going to show it is true by reference to documents. Based on our instructions and the documents that we are going to refer His Lordship to, you were forced, you were threatened, you were insulted, and to put it very simply, you were overwhelmingly pressured to phone Christopher and try and implicate him. Is that correct? That is correct. You didn't phone Christopher of your own accord. That is correct, sir, my lord. And in fact, the allegations, which undoubtedly will come out when the police come, that you actually volunteered to phone Christopher because you said you didn't want to fall, you didn't want to sit for his crimes, that is rubbish. Yes, that is a lie. And your instructions, and we will show that shortly, were unequivocal. If you do not succeed in getting Christopher to implicate himself, you are going to jail for the rest of your life or for a long period of time. That was said to you, not so? Yes, that is correct, sir. In fact, I am going to argue, I am going to show that they were so cold-hearted that one hour after Christopher had buried Jade, they got you to phone him. And in fact, Christopher in that call said to you, Tando, I've just buried my wife. Do you remember that? Yes, he said that. Can I then accept to move off the 29th of April? That when you went to Algoa Park to meet Christopher, firstly, that was an idea that was put into your head by the police. It had nothing to do with Christopher's decision. That is correct, sir. And up until then, if we look at that telephone conversation, that recorded conversation that we have been looking at, Christopher had not made any admission or even suggested that he knew what you were talking about when you said the police were after you. Am I right? He was not even aware of what I was talking about. And amazingly, after you had done the recording with Chris, suddenly you get a lawyer. And I want to put something to you. It appears to me that your request for lawyers fell on deaf ears because they realized that if you used a lawyer, you would not cooperate with them. Am I right? That is correct, sir, because at that stage I was at Kabiga Park. I had already asked for the assistance of an attorney. Then they said to me there is nothing that I will be able to do. I'm going to take it further. You repeatedly asked for an attorney and you were told you will not get an attorney until you implicate Chris. That is correct, sir. And after the meeting in the car, suddenly you get your lawyer. That is correct, sir. The following excerpts mirror the technique employed throughout Sione's questioning by Mr. Price. The answers upheld the proposition. A moment's reflection on his responses established Sione's partisanship to accuse number one's cause, and the exercise conducted hardly passes muster as cross-examination. It constitutes a plethora of leading questions, and the answers furnished have, in my judgment, no evidential value whatsoever. I unreservedly accept the state evidence that at the outset of his interrogation at the unit's offices, Sione, mindful of the dilemma he found himself in, expressed her willingness to fully cooperate with the police and entreated Swanepoel to facilitate an audience with accused number one for obvious reasons, namely to ameliorate the consequences of his own actions. In considering the admissibility of the recorded conversation between Sione and accused number one, the former's concocted version must be disregarded and the matter determined solely on the evidence adduced by the state, to which I now turn. I interpolate to say that the evidence adduced from his mother, brother, and Breakfast's mother that he had been assaulted is in conformity with his own, a complete and utter fabrication, and falls to be rejected. It is common cause that the exchanges between Sione and the unit's members concerning the attempts to telephone accused number one and the actual conversations between him and accused number one were recorded. The transcript was, as adverted to herein before, introduced into the proceedings as Exhibit BG5 and featured prominently in the cross-examination of Swanepoel and the unit's members. As adumbrated herein before, the sole ground initially advanced by Mr. Price for the exclusion of the video and audio footage was the alleged ill treatment of Sione by the unit and the police members involved in his earlier interrogation. During the course of Bosch's cross-examination, however, the exclusionary ground was suddenly widened to now include the scenario postulated by Section 252 capital A2E. It was put to Bosch and later to Swanepoel that the plethora of telephone calls to accused number one on the 28th and 29th of April 2015 inexorably induced him to succumb and meet with Sione, and that this degree of persistence fell foul of the provisions of Section 252 capital A. During Swanepoel's cross-examination, the ambit of the challenge was further extended to now include the scenario postulated by subsection H. It was put to him that the calls made exploited accused number one's emotional state to such an extent that he was impelled to meet Sione. It is indeed so that several calls were made to accused number one, but it is common cause that only a few were answered. In any event, accused number one is the only person who could have told us what effect the calls had on him. Notwithstanding the protection afforded to an accused person by a trial within a trial procedure, accused number 1 chose not to give evidence. That conscious decision has consequences. As Leach J.A. remarked in Hone v. Superstore Mining at 2017, 1 All SA 681 SCA at para 49, moreover, there is no evidence that the appellant in fact acted under duress. Objectively viewed, and in the light of what I have said above, there is no threat of any unlawful evil being done to him if he did not cooperate with the respondent. His counsel had stated in cross-examination of the respondent's witnesses that the appellant would deny that he had made the admissions freely and voluntarily, and would testify that during breaks in the recording he had been further threatened and told that his and his family's lives, including those of his parents, who were employed by the respondent, would be destroyed, and that if he did not admit to provide the information required, he would be imprisoned for life. However, notwithstanding this and despite the unusual protection afforded by the trial within a trial procedure that was adopted, the appellant failed to give evidence. That too was a decision he was entitled to take. But actions have consequences, and one of the consequences that flows from the respondent's failure to testify is the inference that his evidence was likely to damage his case. The reliance on the content of Exhibit BG5 as evidencing impermissible conduct on the part of Swanepoel and his team is entirely misplaced and an exercise in opportunism. An objective analysis of Exhibit BG5 establishes not only that Sione was willing and cooperative, but that the decision to meet rested with accused number 1. His pre-meeting utterances to Sione indicate quite clearly that he recognized that the cat was almost out of the bag, and the decision to meet was to ensure that it remained inside. As adumbrated hereinbefore, accused number 1 elected not to testify during the trial within the trial. Mr. Price nonetheless submitted that such omission is of no consequence whatsoever. Given the assertions made to Sione and referred to in paragraph 41 hereinbefore, the submission is an astounding one. I say so for 2 reasons. Firstly, during Swanepoel's cross-examination, he was referred to the provisions of Section 252, capital A, 2E and H of the Act, and the point was sought to be made that accused number 1 succumbed to the incessant phone calls and met with Sione. Up until then, it was never accused number 1's case that the decision to meet with Sione was in any way actuated by the calls made to him. When I initially invited Mr. Price to indicate the grounds upon which the admissibility of the evidence was being challenged, no reference whatsoever to the circumstances enumerated in subparagraphs A to M of Section 252, capital A, 2 was made. The challenge was, as adumbrated hereinbefore, limited to the generalized defense ex facie the Section 115 statement. Secondly, what I was being asked to do was to infer that accused number 1 in fact succumbed to the incessancy of the calls made to him and met with Sione. The invitation to do so must be declined, for it is based entirely on conjecture. As Boshoff J. pertinently pointed out in S.V. Cooper, 1976-2 essay, 875T at 889 A to C, there can be no inference unless there are objective facts from which to infer the other facts which it is sought to establish. In some cases, the other facts can be inferred with as much practical certainty as if they had been actually observed. In other cases, the inference does not go beyond reasonable probability. But if there are no positive proof facts from which the inference can be made, the method of inference fails, and what is left is mere speculation or conjecture. As pointed out by Denning...
We're going to bring you more on that judgment a little bit later. Right now,
B 355 at page 351 and P 352, the dividing line between conjecture and inference is often a difficult one to draw. But it is but it is just the same as the line between some evidence and no evidence. One often gets cases where the facts prove in evidence the primary facts are such that the tribunal of fact can legitimately draw from them an inference one way or the other, or equally legitimately refuse to draw any inference at all. But that does not mean that when it does draw an inference, it is making a guess. It is only making a guess when it draws an inference which cannot legitimately be drawn. That is to say, if it is an inference which no reasonable man can draw. The facts, in parenthesis, which Mr. Price relies upon in support of his submission, is the contrived version of Sione. The real reasons appear clearly from BG5. All that Sione told accused number 1 was that he was extremely worried because the police were looking for him, he wanted an audience with him, and he wanted money. The argument advanced conveniently ignores the import of Exhibit BG5, from which it is apparent that accused number 1 met with Sione of his own volition and with his own agenda. Although the heads of argument are replete with suggestions that Sione was coerced into influencing accused number 1, and I quote, to implicate himself in Jade's murder, close quotation, a plain reading of Exhibit BG5 establishes the inexactitude of the insinuation. It is not an issue that Exhibit BG5 is an accurate memorial not only of the telephonic interaction between accused number 1 and Sione on 28 and 29 April 2015, but moreover the exchanges between Sione and members of the unit. It was put to the unit's members that Exhibit BG5 establishes that Sione was browbeaten into initiating telephonic contact with accused number 1, and that the latter was induced to meet with Sione and incriminate himself. It is indeed so that ex facie Exhibit BG5, Eckstein told Sione that St. Albans Prison was no bed of roses and that he faced a possible sentence of 25 years imprisonment. It was put to both Eckstein and Swanepoel that such intimation constituted a threat and coerced Sione into making the calls. The assertion made is devoid of all merit, and the utterance by Eckstein, contextually read, amounts to no more than a reminder to Sione of the seriousness of the situation he found himself in. An objective analysis of Exhibit BG5 establishes that Sione was not only the initiator, but a willing and active participant in the undercover operation. This appears clearly from Call 5 on 28 April 2015 and the exchange between him and the unit's members after Call 7, when Sione of his own accord reminds them, and I quote, "You don't understand, Chris is clever," close quotation. Sione's aforementioned categorization of accused number 1 finds corroboration in the exchange between the latter and Eckstein during the afternoon of 29 April 2015, where during the course of their discussion, accused number 1 on several occasions expressed his anxiety at being called by Sione and begs the question why. This show of reticence was feigned and his conduct dramatized to induce Eckstein to believe that there was no connectivity between himself and Sione. A holistic appraisal of the evidence adduced and the content of Exhibit BG5 establish that accused number 1's reluctance to initially either return Sione's calls or to fully engage in conversation with him on 28 April 2015 was actuated by his belief that Sione had in fact been arrested by the police and was calling him at their instigation. Eckstein's uncontroverted evidence was that whilst at the unit's offices in Shirley Street, he received a telephone call from accused number 1 to meet, agreed thereto, and that a discussion took place in his own office at 3rd Avenue in Newton Park. It is common cause that Eckstein recorded this conversation, as appears from my recording 13 on page 25 of Exhibit BG5. It is apparent therefrom that accused number 1's primary motive for the meeting was to establish whether Sione had been arrested. The inference can thus properly be made that, fortified by Eckstein's deception that he had not, he initiated further telephonic contact with Sione during the course of 29 April 2015, which eventuated into the meeting between them later that evening. Exhibit BG5 furthermore establishes not only that the choice of venue emanated from accused number 1, but that he proceeded thence with money to hand to Sione and later blatantly lied to Kun concerning Sione's intended destination. During Swanepoel's cross-examination, the ambit of the challenge to the admissibility of the recorded conversation between accused number 1 and Sione was once more widened to now include the scenario postulated by subsection 2A of section 252 capital A. It was put to him quite erroneously that Bosch had testified that accused number 1 had been entrapped and that under those circumstances permission would have had to be obtained from the Director of Public Prosecutions. The assertion made is misleading in the extreme. The only mention of entrapment by Bosch occurred in the following exchange between himself and Mr. Price, where in response to the question, and I quote, "Now the section 17, you know what section 17 is," close quotation, he answered, "Is that with regard to the entrapment," close quotation. Bosch's rhetorical answer was then elevated to an admission that Sione had been used as a trap. This appears clearly from the following question put to him, and I quote, "Bosch, when he testified, said that the purpose was to entrap Panayiotou. I am using his own words. Is that correct?" There would have been conversations between the two men. We didn't know what to expect. We were just hoping for what to expect. Nee, ek verstaan dit. Ek dink nie u verstaan my vraag nie. Look, I have already obtained permission to make the calls. Now you phone him again. Was that call's purpose only to go a step further to now record him in the car? That is correct, my lord. Mr. Bosch referred to that as the entrapment of Mr. Panayiotou. Do you agree? If that is the wording of Mr. Bosch, that is his. Mine is that we were going to get permission to record Panayiotou. You realize if the court were to find that this was an entrapment, then you would have at first got the permission under section 252 capital A. The proposition made from the Office of the Director of Public Prosecution and the unit required approval for the proposed operation is misleading in the extreme. As a matter of law, section 25 capital A placed no such obligation on Swanepoel. As Wallace A.J. remarked in State v. Kotzer, 2010 1 SACR 100 SCA at paragraph 22 to 26. The section deals with both traps and undercover operations. Whilst these usually go together, there will be cases where an undercover operation may involve no element of a trap. Thus, for example, the infiltration of an undercover agent into a gang planning a bank robbery, a cash-in-transit heist, or the overthrow of a government will not necessarily involve any element of a trap, but may merely be the exercise in obtaining information. Nonetheless, it may involve infringements of the rights to privacy, as with the use of a telephone tap or some other form of listening device, and could potentially be subject to constitutional challenge. The section explicitly addresses that situation and provides that such actions are permissible. It also recognizes that undercover operations may have elements of a trap and hence treats the two together. The present case is a classic instance of an undercover operation that also involves the use of a trap. The section lays down two approaches to the admissibility of evidence obtained as a result of the use of a trap. Evidence is automatically admissible if the conduct of the person concerned goes no further than providing an opportunity to commit an offence. If the conduct goes beyond that, the court must inquire into the methods by which the evidence was obtained and the impact that admission would have on the fairness of the trial and the administration of justice in order to determine whether it should be admitted. It must be stressed that the mere fact It must be stressed that the fact that the undercover operation or trap goes beyond providing an accused person with an opportunity to commit the crime does not render that conduct improper or imply that some taint attaches to the evidence obtained thereby. All that it does is create the necessity for the trial court to proceed to the inquiry mentioned in the previous paragraph. I stress this because there was a misconception in this regard at the trial. At various places in the cross-examination of Treblanche, it was put to him that the section imposes constraints upon what may be done pursuant to a trap, and this suggestion is repeated before us in the heads of argument for Kotze. In summarizing the argument in this practice note, counsel said, die getuienis van die lokvink behoort as ontoelaatbaar gereël te word, aangesien die optrede van die lokvink verder gegaan het as die blote skepping van geleentheid om misdrijf te pleeg. This is a misconception as to the effect of section 252 capital A1, and it is well therefore to lay to rest. Section 252 capital A1 does not purport to describe the manner in which undercover operations or traps are to be conducted by the police. It merely distinguishes on the basis of the manner in which the trap is conducted between instances where the evidence thereby obtained is automatically admissible and instances where a further inquiry is called for before the question of admissibility can be determined. Section 252A1 prescribes a factual inquiry into whether the conduct of the trap goes beyond providing an opportunity to commit an offence. Section 252 capital A2 describes a number of features which may indicate to a trial court that the undercover operation or trap went beyond an opportunity to commit an offence. It was conceded by the prosecution and held by both the magistrate and the court below that the conduct of Treblanche and this undercover operation went beyond merely providing the opportunity for the commission of the offence. Unfortunately, the findings of both courts on this matter were not fully reasoned. A closer examination of the provisions of section 252 capital A1 and 2 is therefore desirable. The starting point is that in each case where the evidence of a trap is tendered and its admissibility challenged, the trial court must first determine as a question of fact whether the conduct of the trap went beyond providing an opportunity to commit an offence. It does that by giving the expression its ordinary meaning and makes a decision in the light of the factors set out in subsection 2. I accept that if one simply peers at the language of section 252 capital A2, there appears to be an anomaly arising from the fact that some matters logically anterior to the conduct of the trap itself are to be taken into account in considering whether it went beyond providing an opportunity to commit an offence. However, there are always dangers in such a linguistic analysis removed from the context of the section as a whole, and the potential anomaly may on closer examination be more apparent than real. Thus, the fact that the trap was set without the authority of the Director of Public Prosecutions or that the conditions set by the Director were disregarded may well indicate that the trap went beyond providing an opportunity to commit an offence. Otherwise, they will be irrelevant. The fact that the offence in question is of a minor nature may indicate that the effect of the trap is to place disproportionate temptation in the path of the accused so that it went beyond providing an opportunity to commit an offence. In considering the question whether the unit's conduct went beyond providing an opportunity to commit an offence, a court is enjoined to have regard to the raft of features adumbrated in section 252 capital 2A to N where applicable. It is apposite, given the confusion surrounding the first of the features enumerated in the subsection, to dispel the notion that the authority of the Director of Public Prosecutions is a prerequisite for the engaging in an undercover operation by a law enforcement officer. The Act imposes no such duty, cadet quaestio. As adverted to earlier, section 252 capital A did not oblige Swanepoel to obtain the Director of Public prosecution's consent to conduct the undercover operation. There is furthermore no suggestion that other techniques were available to unmask Jade's murderer. It is common cause that Jade's murder had unleashed a media frenzy. It, together with the informant's revelations, and confirmed by Sione, impelled the adoption of a strategy employed by the unit, and their modus operandi is not open to critique. An objective assessment of Exhibit BG5 establishes that accused number 1 was not induced into meeting with Sione. It was his own self-preservation which caused him to make the calls which in fact precipitated the meeting. The mere fact that the initial calls were made at the instance of the unit is entirely irrelevant. The fact of the matter is that the majority went unanswered, and when regard is had to the import of the actual conversation between accused number 1 and Sione prior to the actual meeting, it is clear that no exploitation, as envisaged in subsection 2H, in fact occurred. Pardon. It is furthermore clear that the evidence procured established accused number 1's complicity in Jade's murder, and there is no room to contend that the unit acted in bad faith. I am satisfied that the unit's conduct did not go beyond providing an opportunity to commit an offence. But even on the assumption that it could conceivably, upon an entirely subjective critique of the unit's conduct, be contended that it went beyond providing an opportunity to commit an offence, the evidence garnered would, in my view, nonetheless be admissible, for its admission is neither unfair nor detrimental to the administration of justice. Rather, its effacement would be inimical to the interests of justice. The aforegoing constitutes my reasons for ruling that the audio and video recordings Exhibit CB1 is admissible in evidence. During his final address, however, Mr. Price entreated me to revisit my ruling, contending that the evidence adduced during the defence case justified its reconsideration. It is indeed so, given the interlocutory nature of rulings on the admissibility of evidence, that a court is entitled to reconsider its earlier rulings, but the argument is advanced is spurious, proceeding as it does from the misconception concerning a law enforcement official's power to engage in an undercover operation. As adumbrated herein before, Section 252 capital A imposes no obligation on a police officer to obtain the Director of Public Prosecution's consent to engage in such activity, and the adduction of testimony by advocates Gandon and Gobadon from the Office of the Director of Public Prosecutions was, despite the fanfare, entirely irrelevant, and so too the guidelines. Whilst these may apply to members of the prosecutorial services, they are clearly not binding upon members of the South African Police Services. The import of the aforementioned dialogue between Sione and accused number 1 establishes his complicity in Jade's murder beyond all reasonable doubt. Its admission into the smorgasbord of testimony against accused number 1 nonetheless evoked an assault on the authenticity of both the video presentation and the transcript of the recording. Warrant Officer Kelamani, attached to the Electronic Surveillance Unit of the South African Police Services, was responsible for downloading the video recording from the SD card onto his computer. He burned the DVD, received in evidence as Exhibit CB, and the transcript of the conversation as Exhibit CB1. During cross-examination by Mr. Price, it was suggested to him that both the video and audio presentations could have been manipulated. Whilst it is correct that Kalamani assented to this speculative hypothesis, the attack soon dissipated and was abandoned. Nonetheless, the attempt to impugn its genuineness was imprudent and symptomatic of the malaise which afflicts the defence case. The video and audio recording provides a graphic account of the interaction between Sione and accused number 1 and posits the latter as the preeminent villain. The transcript is unsusceptible to paraphrase, and its reproduction into this judgment is imperatively called for, particularly in light of accused number 1's disavowal of any complicity in Jade's murder and the unwarranted and scurrilous imputations of dishonesty directed by the defense against several witnesses called by the state. It reads as follows: TS referring to accused number 1 and CP refers to the accused number 1. Things aren't right now. Why? Babalwa called me and said the police was there at my house. Everything is changing now. But why are the police after you? I don't know. I think there is an informer somewhere, somehow. Did these guys blit? Which ones? Your friend, Sizwe. Did they tell anything? No, even them, they are on the run. Oh. I told them they must not be here. Where are they going to? They didn't tell me. I changed my SIM card. Yes, but you need to change it again now. After this I'm going to call you. What? I'm going to call you on my new number. No, you are not. You just missed call me. Don't phone me or SMS me. What's going on, boss? I don't know, bro. Hey, this thing, I didn't see it was going to be like this. Yeah, what is this? Plus minus 5, reference to 5,000. Where are you going to now? I'm going to Jeffreys Bay. I'm worried about my family. Boss, this thing, I didn't know it was going to be like this. I thought it was going to be easy. Yes, but why did they say to you when they fetched you the other day? They fetched me and then they asked me questions. What did they ask you? If questions. Hey, nothing serious, boss. Tell me. Did they ask if you were involved? Yes, sort of something like that. So what did you say? Those are the stupid ones. So where did they take you? They took me to the police station. There they took my statement. But in my mind, you must told me we will be investigated. Yes, so I was ready for that, but I was not ready. So why are you running away? They keep coming to my house. Did you take your phone anywhere? Yeah. No, your other phone. I destroyed it. Did you? I told them to destroy it and then I destroyed it. Yeah, and the SIM card and everything, did you throw it away? Yes, I'm not using the old number. I'm using this number. Okay, so they didn't ask anything about me? No. Or if I'm involved or anything? No, yeah, but they haven't. But haven't they asked you? Yes, they have asked me, but now, you've been phoning me all day and they've been tracing my phone. The thing is, who could I call? I had no one to call. I know, but now you have to destroy that phone. I have to tell them that you phoned me, otherwise they are going to think that I am involved. Yeah, so you need to destroy that phone now. The phone and the SIM card, my boy, both. Yeah. I interpolate to say that at this juncture, the video shows accused number 1 seated on the front seat of the vehicle, turning around and frisking Sione. The transcript continues. I don't trust you now. Oh, I'm just checking. Even me, I'm not trusting you now. Just the thing of the police that are coming to my house. I swear on my life I didn't say anything, but they are obviously seeing who I have been phoning. They are taping my phone and my every number I phone. They are investigating my family too. Somebody said something. Yeah, because it's like a murder thing now. It's not like a robbery or something. But that's what I said to you. It became a kidnapping and a murder instead of just making it a robbery outside the house. I think about my family now. I think about Sianda. I think about the 2 little girls. I think about my gym. They went to search your house, says Sianda. Sianda says so, you see. But there's nothing there, so stop stressing. You know why I'm actually stressing? I'm not safe anymore. Because I have to run away even from Sizwe, because I told you, Moss, what Sizwe said. That money was too little because now they are running away too. Yes, but it is because of them, Tondo. They made it the way they did. They made it so big, but they have run away. How many of them? I don't know. I only know Sizwe. Is it black guys or colored guys? Sizwe is a black guy. And the others? I don't know if the others, but I know Sizwe. I was communicating with Sizwe. But I don't know if Sizwe was walking alone. Okay, listen to me. I'm going to report that you found me now, and then you are going to call me. No, but you are going to destroy that phone. So you are going to give them my number. Yes, I have to tell them. They're investigating me. If I lie to them, they're going to take me in. So I'm telling you, in half an hour, I'm going to phone the investigating officer. He was at my house now. That's why I can't talk to you all the time. And my uncle is around. He's all around me. So I'm going to tell them that you came to see me wanting to borrow money because people took you for questioning for steroids. You need to go and hide in Jeffreys Bay for a while and keep quiet. Sianda, what about the rent for the gym? Yes, but I can't do anything because I'm under investigation, so I can't give over money all the time. So don't worry me, and Sianda will talk. Yeah. Okay, are you going to hide out that side in Jeffreys? Yeah, I'm going to stay a while there, or maybe some. Okay, I'm going to say you must destroy your phone now and the SIM card, and I'm going to say you said you're going to East London. Okay. Okay, I'm going to be okay as long as they never know about us, Tanda. I only ever helped you with the gym. I never did anything with you. I'll sort out your family. You lie low, okay. You need to be gone for a few months till this thing calms down. If I need you, I will miscall you. No, not on this number. On what number? You're going to miscall me once and then you're going to wait until I get another phone and a SIM card. Yeah, all right, okay. There is about 5 there. You sort yourself out. Yes, okay, because I'm all out now. This thing has cost me a lot of money. The family is also looking at me. Serious, yes, okay. This thing is not right now. No. These boys made it big. I told you to let them do it outside the house and take the bags and the rings, and then they didn't take the watch or anything. They just left. They just left everything there, you see. So now it looks like a hit now. So they are after me, and that's why I can't just meet you in front of people like this, Tando. Okay. Okay, don't phone me and don't SMS. They are watching the SMS because you said. Yeah, but I SMS you and you don't reply. Me at the other side, I'm hiding, and then, no, but you need to give me time. So from now on, you just give me one missed call on this number, first time and never again. Don't ever phone me or SMS me to this number because they are listening to us. Even now, well, yes, but I put it off. When you were talking on the phone, they are listening. That's why I have to report this now. Okay, all right, I'm going to say you are going to East London. Okay, Chair, so I need to miscall you. Yes, but then you wait for me to phone you back. It will be gleaned from the aforegoing and the video footage that after accused number 1 frisked Sione, there is a discernible attitudinal change in the interaction between them. His initial circumspection all but vanishes, and the intricacies of their murderous conspiracy are laid bare by accused number 1's forewarning, and I quote, somebody said something, yeah, because it's a murder thing now, it's not just like a robbery or something. It became a kidnapping and a murder instead of just making it a robbery outside the house. Close quotation. The aforegoing unsolicited utterances and admissions by accused number 1 vouchsafe the truthfulness of both the narrative in both Breakfast and Sione's police statements and demystifies the concocted defense. Particularly telling is accused number 1's comment, and I quote, I told you to let them do it outside the house and take the bag and the rings, and they didn't take the watch or anything. Close quotation. It is not in dispute that when Jade's body was discovered in the veld, her watch was still on her left wrist, slide 45, exhibit 8.1, and her bracelet on her right wrist, slide 54, exhibit A1. The presence of these items of jewelry no doubt perturbed accused number 1, hence his earlier comment, and I quote, because it's not like a robbery or something, close comment. His language usage clearly imparts his displeasure at their modus operandi for, as he remarked in our open quotations, "It's like murder thing now," close brackets. An analysis of the conversation furthermore establishes that accused number one had direct knowledge of Vumazonke's involvement in Jade's murder. This is evident from Sioni's comment, and I quote, "Because I told you what Sizwe said, that money was too little," close quotations. Whilst it is correct that they were not privy to the identity of Vumazonke's fellow villains, accused number one was acutely aware that Vumazonke had not acted alone. The aforegoing startling admissions of accused number one's complicity in Jade's murder held dire consequences for him, and a strategy had accordingly to be devised. Into this breach stepped Mtembu, the case referred to in accused number one's plea explanation. However, in order to successfully raise the defense adverted to in Mtembu, a victim of torture had to be sourced, and Sioni, a nefarious individual who bore the mark of an ostensible assault, was earmarked as the ideal candidate to be moulded into the battered victim of torture in Mtembu. It is no surprise, therefore, that when Sioni was led, his description of the alleged assault on him was, and I quote, "I was tortured," close quotation. Accused number one's entire case is predicated upon Sioni's alleged torture, and during the course of the trial and in argument I was regaled with sonorous accounts of the decimation of his fundamental rights. This vituperative assault on the integrity of the police officials and the prosecutor was to be expected, given the absence of any valid defense to the charge. As Adam adumbrated before, Sioni is an unadulterated liar, and the salutary remarks enunciated in Mtembu find no application in this matter. At an earlier stage of this judgment, I referred to Sioni's volte-face concerning the origins of the 31,000 rand, which the police found in his gym bag, and his demure admission that it constituted the balance of the 80,000 rand which he had received from accused number one, destined to Vumazonke for the contract killing. In Exhibit AY1, Sioni recounted a visit from accused number one late the evening when the latter handed him a bag containing money. In Exhibit V25, Breakfast likewise narrated the circumstances under which Sioni came into the house and asked her to count the money. It is common cause that accused number one went to Sioni's home during the late evening of 22 April 2015. The exculpatory assertions made apropos this nocturnal visit are nonsensical. Its purpose, first and foremost, was to deliver the money demanded by Vumazonke. A substantial portion of the trial was devoted to establishing the origins of the money, but once the debris is removed, it is clear that accused number one retrieved it from his business premises at the time he disabled the alarm system. It is thus wholly unnecessary to embark upon an evaluation of the evidence of the host of witnesses who were called herein. Sioni's sanitized version of its source and destination renders that exercise unnecessary. Sioni's evidence herein was, given its earlier non-incriminatory character, a shot out of the blue. In his revised version of the circumstances under which he came into possession of the 31,000 rand, he recounted going to his place of employment with Vumazonke, and whilst the latter remained behind in the vehicle. He entered the premises and then narrated how accused number one came into Infinity at some unspecified time, sent Vuyokazi to call him, and then handed him the money with instructions to hand to Vumazonke. This shocking revelation was inimical to accused number one's claim to innocence, but as the adage goes, even liars tell the truth sometimes. Sioni's disclosures, not unexpectedly, raised the ire of Mr. Price, who sought its expungement on the grounds of hearsay, but I allowed the evidence to stand. During his cross-examination, Mr. Price was thus constrained to exercise damage control, which he sought to achieve by the following assertion, and I quote, "I am not saying you are lying. I am saying you are making a mistake when you say that Christopher gave you 80,000 at OK Grocer to give to Vumazonke." Close quotation. Sioni's riposte was, and I quote, "I am not making a mistake." In evaluating the revised version of the source and destination of the 80,000 rand, it is apposite to refer to Exhibit AY1, where Sioni recounted having received the money whilst in a car outside his home on the evening of Jade's murder. In Exhibit V25, Breakfast confirmed that when Sioni entered the house after meeting accused number 1 outside, he had a bag of money and asked her to count it and leave 50,000 in the bag and the balance to one side. Sioni's viva voce evidence thus provides substantial corroboration for the content of both Exhibits V25 and AY1 and proves beyond any reasonable doubt that accused number 1 knew who the recipient of the money was. Further corroboration is to be found in the conversation between accused number 1 and Sioni on the evening of 29 April 25, where he says, "TS, you know why I'm actually stressing? I am not safe anymore because I have to run away even from Sizwe, because I told him what Sizwe said. That money was too little because now they are running away too. CPS, but it's because of them, Tando. They made it the way they did. They made it so big, but they have run away here. Yeah, how many of them?" It is difficult to conceive of a situation where Sioni could be mistaken about the source and destination of the 80,000 rand. It was never put to him that he was being deliberately untruthful, and yet other witnesses had been castigated as liars for their testimony concerning money left at OK Grocer. The underlying reason for Mr. Price's mild-mannered disposition towards Sioni is self-evident. He was complicit in accused number 1's concocted defense and could accordingly not be rebuked for his faux pas concerning the 80,000 rand. As adumbrated herein before, this is the only aspect of Sioni's evidence which I accept as truthful, and it, coupled to the absence of any rebutting evidence by accused number 1, perfects the mosaic of the state's case against him. There is no dispute concerning the precise location where the deceased's body was discovered. That she had been conveyed there in a vehicle from her home in Port Elizabeth, however, admits of no doubt. The evidence adduced by the state and detailed hereafter conclusively establishes that prior to 21 April 2015, Jade and her colleague, Ms. Swanepoel's movements, places of abode and employment had been monitored and kept under surveillance as from 9 April 2015. As I shall in due course detail, the data retrieved from the car tracking device installed in a white Toyota Etios, the Etios bearing the registration letters and numbers FYM 661EC, provide irrefutable proof that it was the instrument whence the monitoring and surveillance referred to was conducted, and wherein the kidnapping and ferrying of the deceased on 21 April 2015 was effected. The first inkling that the Etios had been used to transport the deceased arose quite fortuitously when Warrant Officer Johannes Jacobus Boertes, one of the members of the unit, interviewed the owners of the vehicle. Before I analyze and evaluate that evidence, however, it is apposite to dispel the notion that testimony incriminating the erstwhile accused number 2, Sizwe Vumazonke, with the offences preferred against the accused, was inadmissible. Prior to the resumption of Boertes' evidence in chief vis-à-vis the movement of the Etios on the morning of the deceased's disappearance, both Mr. Price and Mr. Doberman objected to the reception of such testimony. The objection by Mr. Price was formulated thus: "My Lord, since yesterday we have been taking instructions from the family, and we have spoken to very senior counsel throughout the country, because something has been worrying us from the word go, and I need to address it with your Lordship right now. Lord, we feel that we are being ambushed. I'm not talking about ambushed in the sense that we are getting very poor statements. I'm not referring to that at all. But from the word go, apart from Mr. Ndedwa, Mr. Lord, we have just had witness after witness testifying about Sizwe Vumazonke's role in this case. Lord, Sizwe Vumazonke is not before you, and what makes it extremely difficult for us representing Mr. Panayiotou here, Mr. Doberman can speak for himself, is that we are feeling obliged to ask questions from a witness who is not before the court about a witness from whom we cannot take instructions. Now, Ms. Bakker and his attorney, we have obviously consulted with them, and they have very strong and at times, in my opinion, pretty good instructions to challenge various witnesses, for example, the cell phone experts, etc. But we are not in that position, my Lord. And what is happening here is that we are being forced to defend Vumazonke when he is not before this court and when we cannot defend him. Now, my Lord, my instructions are to ask your Lordship to one of two things. One, that this evidence relating to Vumazonke and any other further evidence relating to Vumazonke's role in this matter should be disallowed. He is not before this court, he is not an accused. Aligning himself with the objection raised, Mr. Doberman submitted that, my Lord, the difficulty is that the state is going to seek to rely on evidence against an erstwhile co-accused who is not before the court, which I am basically not able to test properly during the trial. The state relies on the doctrine of common purpose and also alleges a conspiracy with that particular accused who is no longer before you, my Lord, and who is not represented here. So in essence, accused number 3 and accused number 4 basically just have to accept whatever evidence is placed before your Lordship in relation to that accused. We simply are unable to test the evidence, and we have to face that evidence blindly. So in those circumstances, the question arises whether that evidence should be ruled admissible or not. My Lord, and just for the sake of formality, I'm going to object to that evidence being adduced, the evidence relating to accused number 2, my Lord, and I'm going to ask your Lordship to make a ruling now on that issue, whether that evidence should be allowed. So I note my objection, Lord, on that basis. I overruled the objection and allowed the further adduction of witnesses' testimony. The general rule is that all relevant testimony is admissible unless excluded by a specific rule in the law of evidence. This inclusionary aspect of the relevant criterion was explained by Inna CJ almost a century ago in Rex v. Trapedo, 1920 Appellate Division 20 at P62 as follows. The general rule is that all facts relevant to the issue in legal proceedings may be proved. Much of the law of evidence is concerned with exceptions to the operation of this general principle, as for example the exclusion of the testimony on grounds of hearsay and remoteness. But where its operation is not so excluded, it must remain as the fundamental test of admissibility. One of the myriad of issues which fall for adjudication in this matter relates to the question how Jade, destined to be driven by Miss Swanepoel from her home in Deacon Street in Port Elizabeth to Ribbear College in Uitenhage, ended up in the veld on the outskirts of KwaNobuhle. The evidence which the state initially adduced by Boetes was directed to establishing that she had been transported thence in the Etios which had been hired from Zems. Boetes had established from Mrs. Zulfa McCarthy, Zem's owner, that Vumazonke had hired that vehicle. Such evidence was clearly admissible, and as I shall in due course elaborate upon, crucial. The objections raised with much hullabaloo to obfuscate the real issue had as its object the suppression of such testimony. I know of no exclusionary rule where more than one accused is charged, and prior to the commencement of the trial one dies, testimony implicating him or her in the commission of the offence or offences charged is thereby rendered inadmissible and to be excluded from the conspectus of evidential material. It is not an issue that the manhunt for Vumazonke was triggered by the revelations made by Sione, where after a tracking team which included Sergeant Tapelo Mabija, Siyabulela Manakaza and Buerta set off on a fruitless search of him to Cape Town. It is apparent from their testimony that Vumazonke had, however, been forewarned of the police's hot pursuit and had returned to Port Elizabeth. The tracking team followed certain leads and observed him at a party in KwaNobuhle. Vumazonke left and proceeded to a tavern, surreptitiously followed by the tracking unit. Mabija recounted that Vumazonke stopped, alighted, and spoke to an unidentified person who ran away when the tracking unit's members approached his vehicle. Vumazonke, who at that stage was seated in the vehicle, opened the door in an attempt to flee, and in the process of them trying to prevent his escape, he hit his head on the side against the side floor panel. Vumazonke was arrested and transported to the Kabiga Park police station. His possessions, including his three cell phones found in his possession, were booked into this SAP-13, to wit a BlackBerry 8520 model IMEI number 3612-570-054-59562, a battery, MTM SIM card number 28699299960, a 26B micro SD card, a white Samsung cell phone, IMEI number 3534-2006-329-0590, one battery, and a Cell C SIM card number 89270-760-1141-067-634, and an iPad with a serial number FSW LFY OAF196. Mabija recalled that the vehicle which Vumazonke had been driving was a silver grey VW Polo sedan bearing the registration letters and number CAW34942. The thrust of Mabija's cross-examination by Mr. Price related to the injuries sustained by Vumazonke and the alleged violation of his rights. Its aim was to establish a pattern of conduct by the police to corroborate Sione's evidence that he had been assaulted. The remainder of his testimony went unchallenged. It is not an issue that the unidentified male who fled the scene immediately prior to Mabija and the tracking team descending upon Vumazonke's vehicle was his distant relative, one Mr. Siloleko Leon Kirana. During the course of that evening, he had borrowed the vehicle from Vumazonke and had plugged his cell phone charger and cell phone in the cigarette lighter portal. When he eventually met with Vumazonke and left the SK2 tavern with Vumazonke and his girlfriend, Vumazonke had surreptitiously, and for reasons not germane to this judgment, handed his cell phone to him. When the vehicle stopped and the shots rang out, which caused him to flee the scene, he did so whilst in possession of Vumazonke's cell phone. As I shall in due course advert to, this is the very phone which Vumazonke accused the police of having stolen after his arrival at the Kabiga Park police station. Kirana's evidence concerning the circumstances in which he came to be in possession of Vumazonke's cell phone was assailed by Mr. Doberman as untruthful, but the criticism is unfounded and born of desperation. Kirana's testimony establishes that the number of the cell phone handed to him by Vumazonke was 0832691194. Its relevance would in due course crystallize. Mabija's testimony concerning the futile manhunt for Vumazonke in Cape Town was corroborated by Buertas, who had been assigned to the tracking team by Brigadier McLaren, the provincial head of the detective services in the Eastern Cape. Buertas narrated that he first saw Vumazonke at approximately 3 a.m. on 3 May 2014 and observed that his right eye was swollen. In his evidence in chief, he adverted to his role in returning the VW Polo to its owners during the course of that afternoon. Buertas had already established that the vehicle had been hired from Zem's car hire on 21 April 2014. During that telephonic conversation, he had arranged that he would deliver the vehicle to them, and duly did. McLaren, though not physically present at the scene of Vumazonke's arrest, was in the area, and it was to him that the tracking team proceeded on the arrest of Vumazonke. Buddhist narrated that during the discussion with McCarthy, the owner of Zems, he perhaps presently, asked her whether Vumazonke had not previously hired vehicles from her. A perusal of the records, Exhibit U, revealed that Vumazonke had hired a white Toyota Etios bearing the registration letters and number FYM661EC for an initial period of 2 days, but subsequently extended until 23 April 2015. Upon being appraised that that vehicle had been fitted with a tracking device, Burtis asked her whether she would be able to retrieve the data relating to the vehicle's movements on 21 April 2015. Burtis's account of the data displayed on the computer screen, and which would later be corroborated in all material respects by McCarthy, was as follows. Then I requested her to switch on the computers for me. I also informed her that she was compelled to show me that, and then we switched on the tracker record of that vehicle, FYM661EC. We switched that on, the tracking record of the 21st, the day on which Mrs. Panayiotou was murdered, and that was just after 6 o'clock. Then we followed the record of the tracker from KwaNobuhle, that is to KwaZulu. Now we did it live, the short distances that he was driving, and it showed us pieces and bit by bit, but it did not show anywhere where it stopped for a long time. Then at the residence of the deceased, it was red lines as he was driving around in that area. He did not drive away directly from the residence, but it was in the vicinity, within the area of her residence. Now if I can just interrupt you. At that stage, were you aware where the deceased was residing? Is that correct, sir? Yes, my lord. Goed en van daaraf. Now, when they allegedly picked up the deceased, they drove around a road that went through the back, that is through Rocklands. Then Mrs. Chunara said to me, perhaps he is going to turn into the right in KwaNobuhle, into KwaNobuhle. Then I said to her, no. Then we followed the route further up the first gravel road, where he turned into to the left. And Mrs. Shonara at that stage got very emotional. Then at the farm where the deceased was murdered, I said, now he is going to turn into right. Mrs. Shonara started crying at that stage, saying that my car has been used to murder the deceased. Then I tried to calm her down. I said, ma'am, just please come on. It is just plus minus 400 to 500 meters, and then we will be done. Then we followed the red line, and precisely where the deceased was murdered, there were 2 yellow spots. That was where the car made a turn. You are also aware as to where the deceased was found? Yes, I was aware, my lord. And is that the place where the vehicle came to a standstill? I cannot say precisely, because that is from a GPS card that I followed. I cannot say with precision where it stopped, but it was just according to the knowledge of my avail that I said it was going to follow 400 to 500 meters before it turned around, and according to me, that is where the car turned back. So was that sufficient information at your avail to draw the inference that car was used in committing the murder? Yes, my lord. That answer concluded Burtis's evidence in chief, and Mr. Price was then called upon to cross-examine him. It failed to materialize on that day, and the first salvo was fired of what was to become a constant lament throughout the trial, namely, and I quote, "This is a trial by ambush," close quote. It is apposite at this juncture to state that this constant and complete and repeated complaint is without any substance whatsoever, and a deliberate ploy to obfuscate the real issue. The contract data referred to above was introduced into the proceedings by Mr. Lawrence Stoger, an employee of contract. During his prefatory testimony in chief, he adverted to his experience in the tracking industry for the preceding 20 years and knowledge of tracking devices. He identified the installation certificate of the tracking device installed in the Etios, Exhibit A-B, and described its operating system as follows. The fleet management unit fitted to this vehicle uses what we call GPS technology to accurately pinpoint the position of the vehicle. The product type of the unit will be prompted to position from the time that the vehicle's ignition is turned on up until the time the vehicle's ignition is switched off. The firmware on the unit will update at a series of events which we call a trip. This information is calculated at every 5 degrees direction turn of the vehicle, every 3 kilometers in a straight line, and lastly, in the event of an exception. An exception is generated through the accelerometer which is fitted to the vehicle. These exceptions allow us to manage driver behavior. These measure G-forces. Typically, you would notice exceptions such as harsh braking, acceleration, and turning. I would also at this point like to make it clear for the court how this technology is used to accurately pinpoint the position of a vehicle. GPS, or Global Positioning System, is a worldwide recognized technology. The technology was developed by the United States military back in the 70s, and the purpose therefore was to manage and monitor their assets around the globe. In the 90s, I think it was in the late 90s, this technology was released to the public, which allows anybody today with a smartphone or a GPS device to track your position and navigate your way around. This positioning is achieved via a process of trilateralization. Repeat again, trilateralization. Yes, basically, at any given point there are 30 satellites circumnavigating the globe, and the GPS receiver will lock onto a minimum of 3 satellites to accurately position the vehicle or smartphone or TomTom or Garmin device or any device that is fitted with a GPS receiver. Its reliability and integrity is, despite initial hubbub, not open to challenge and clearly admissible. It is not an issue that the raw data recovered from the Fleet Management Unit is reflected on Exhibit AA. A detailed travel report of the movement of the ETIAS from 13/25/05 on 9 April 2015 to 25 April 2015. At the conclusion of Stoger's examination in chief, both Messrs. Price and Doberman sought leave to consult their own experts as a precursor to cross-examining the witness. When he was recalled for that purpose, Mr. Doberman raised an objection to the evidence tendered by him on the basis that, and I quote, "He has not been properly qualified as an expert, and that my learned friend was therefore not entitled to lead that evidence, which the opinion evidence, which is irrelevant and not admissible in those circumstances." I close quotation. I overruled the objection, and counsel for the state sought leave to put further questions to him concerning the unit's accuracy. This request elicited a further objection, ostensibly on the supposition that Stoger would now expand upon his expertise. Mr. Stander, however, refrained from any further examination in chief. The objection raised to the admissibility of Stoger's testimony is entirely without merit. It is abundantly clear both from his prefatory discourse and evidence adduced concerning the operating system of the unit that he is eminently qualified to express an opinion. As Imtiani J.A. adverted to in State v. Mlimo, 2008-2 SSCR 48, at paragraph 13, in my view, a qualification is not a sine qua non for the evidence of a witness to qualify as an expert. All will depend on the facts of the particular case. The court may be satisfied that, despite the lack of such a qualification, the witness has sufficient qualification to express an expert opinion on the point in issue. It has been said it is the function of a judge, including a magistrate, to decide whether the witness has sufficient qualifications to be able to give assistance. The court must be satisfied that the witness possesses sufficient skill, training, or experience to assist it. His or her qualifications have to be measured against the evidence he or she has to give in order to determine whether they are sufficient to enable him or her to give relevant evidence. It is not always necessary that the witness's skill or knowledge be acquired in the course of his or her profession. It depends on the topic. Thus, in R.V. Silverlock, it was said that the solicitor who had made a study of handwriting could give expert evidence on the subject, even if he had not made any professional use of his accomplishment. I'll take the adjournment now, and the court will resume at 2:15.
Report.